Welcome to the Legal Talk series on vaccination information in the workplace. My name is Julia. I'm here with Yoness Blackmore, Workplace Relations Law Specialist, and our Senior Legal Writer for Practical Guidance Employment. Yoness, vaccination seems to be the only thing everyone's talking about at the moment.
It certainly does, and it's a tough issue for businesses and workers. I think that many workplaces have already worked through this process and decided what they're going to do, and no doubt workers have made their own decisions around that too. But I think one of the sort of issues that needs a little more focus on vaccination is whether or not businesses can actually keep the records about their workers' vaccination status or their medical reasons for not having that.
Surely, I would have thought businesses could keep this information. I mean, it's all about safety, right?
Well, I guess, yes, it is. But unfortunately, as is often the case in the workplace world, it's not so simple. So the issue here is that we're talking about health information, and that's sensitive information of a person. And it could be either their vaccination status or their medical contraindications both fall into that bucket. And what that means is for covered businesses and government agencies of the Commonwealth, they'll need to comply with the privacy legislation and the Australian privacy principles, or face fines. Government agencies may also have to do privacy impact assessments as part of it as well.
That's so complicated. Well, then how do businesses go about recording vaccination status?
Well, there's a couple of things they need to do, and again, that's because we're talking about sensitive information here. Firstly, the actual collection itself, so the recording of the information, that needs to be reasonably necessary. So there needs to be a good reason to do it, not just because you want to tick a box on a form, but because you need it essentially to provide evidence of something. And the second thing that needs to be done by an organisation is to make sure that the person providing the information, whether they're an employee, a contractor, a volunteer, make sure that you get valid consent. And so this means you have to provide all these people with adequate information. You need to make sure that consent's voluntary, so you're not forcing them or applying duress to them. Whether, threatening to sack them takes away the validity or not, that may be a question in some circumstances. And the workers need to sort of be able to understand what's going on. The only time when you don't need to get that valid consent is really if there's an exemption. So if a law actually requires you to collect the information. So a public health order usually requires certain information to be collected. And it may be the case with, many of these workers, employees or contractors, that they actually have a contract of employment or for services that has a condition in it which requires them to have a COVID vaccination and to provide evidence of that. Now, connected with all this, because it always has to be a little bit more complicated, is when business is going about getting valid consent, if they need to, there is also some obligations under the Therapeutic Goods Act, and there's a permission that's been put out that applies to the types of communications or information that can be given to employees or, again, contractors, so I'll say workers here, and that information needs to be factual, it needs to be balanced. You mustn't just be promoting a vaccine as such or advertising. So there are certain strict rules in there. So that slightly also complicates the obtaining of valid consent, because you need to, as part of that, provide information, but the information you provide also needs to comply with that TGA permission.
So where there's no public health order, can they refuse?
Yeah, so really, a staff member could refuse irrespective. Probably in the context of a public health order, that would be the end of that. They probably wouldn't be able to remain employed if they couldn't provide evidence. But for other workers, unless there's specific requirements in employment contracts, or there's some agreement around it, employees may certainly refuse to provide evidence, and really the role of the organisation then is to prove or make it clear the reasons why they actually need it.
Well, can employers just give lawful and reasonable directions to employees to provide this information?
Well, if it's a lawful and reasonable direction, then yes, of course. But if the employer, because we're talking employment here, hasn't complied with the Privacy Act and hasn't obtained valid consent and there's no exemption, then the direction won't be lawful and reasonable. So we may all remember a case called Lee against Superior Wood, which was a full bench Fair Work Commission case, and that was all about an employee who refused to provide fingerprint information to be recorded. And when Mr. Lee was sacked, he was unfairly dismissed, and it wasn't in that case a lawful or reasonable direction to try and force him through duress to provide consent, and therefore there was no valid reason for his dismissal. And a bit more complicated in the case, but essentially the real question here is the direction reasonable and lawful, and well, it maybe not, especially if you don't comply with the Privacy Act requirements.
I see. Could employers offer incentives to provide this information?
Yes, they certainly can. And I think, it's pretty obvious that no one likes being told what to do. No one likes mandates. And, we see a lot of demonstrations and a lot of objections to that. And I'm not commenting in any way on those things, like, that's human nature. So if one can persuade, and by mutual agreement, get yourself into a situation where staff willingly, provide proof of their vaccination status in return for, a day off or a gift or something like that, then I would imagine that is a positive outcome and a good thing for morale. But you just also, of course, have to keep in mind that we're talking, about a drug here, and again, the Therapeutic Goods Act comes in, and that permission, again, the legal permission, not only applies to guide businesses on the information that they're providing their employees or contractors or other staff to get consent, but it also regulates the types of benefits or rewards that can be offered to workers. And so businesses need to be across those requirements before kind of launching into the let's give a present for that information. But I certainly think that taking a positive approach is a good thing.
Well, if we have agreement, then do we just ask for a copy of the immunisation history statement or COVID digital certificate?
So again, I guess we just need to take a step back. If it's a public health order and it says that's what you need, then it's pretty clear. If you're a business, though, just your standard business or organisation, then you need to look at really what's reasonably required. I mean, do you actually need copies of those things to be kept on a record, or do you need a copy of the medical certificate specifying the contraindication? Or, can you just tick a box on someone's vaccination status and the date, or the date of the vaccination? That's the kind of, I guess, simplest level of data you could keep. Or you could simply cite the certificate, and not record anything. If you don't record it, then you're not collecting it, and then the Privacy Act doesn't even apply. I suspect, however, you probably, if you're pushing and supporting vaccination in the workplace, including as some sort of incentive program, then you probably would want to just have some middle ground, and having a tick box sort of exercise is probably what you might be looking at there, and maybe something that is easier to get from staff than actually a copy of something that is so, so sensitive as an immunisation history statement, which of course also requires, the whole lot of additional requirements in terms of keeping those things secure and ensuring that they're actually valid and not fraudulent. Once you start taking the evidence, I guess it adds a whole lot of other considerations into it.
Is there anything else that a business should think about when putting a process in place to collect information about vaccination status?
Yeah, at the point of collection, the Australian privacy principles apply to all covered organisations. So that's the other thing that we got from that Superior Wood case. It said even though there's this employee records exemption, it's not applicable at this point. So what that means is when you're not only getting consent and thinking about whether you need this information, but you also have additional obligations around that. You need to be transparent about the purpose of having it. Like, is your purpose to satisfy the public health order? Is your purpose to meet some specific workplace safety requirement? I guess the purposes behind the mandating or not of the vaccination, the first place, all these things kind of hang together. You also need to be telling the person what's going to happen if they refuse to provide it. You also have your minefield. Are you going to sack someone if they refuse it? Do you really want to do that? You need to talk about if there's any law that might justify the collection. So again, it could be a public health order or it could be the Work Health Safety Act and you trying to ensure that you have compliance procedures in place that support you maintaining that safe environment. And then you need to be clear about the how you'll be using and disclosing that information. And again, public health order, you might have to, I don't have one in front of me, but you might have to notify some agency to confirm, or there may be some process you need to comply with there. So you need to provide that information and be specific about the purpose and understand that the basis upon which people are providing it to you is the basis upon which you need to deal with it. You can't use it for some other purpose or, some marketing exercise, for example, where a business might say, oh, we've got whatever, portion of people in this particular team vaccinated. So just keep it all consistent in terms of purpose. You then also need to make sure that it's kept securely. It can be accessed and corrected by staff. Again, noting the employee record exemption does kick in after collection, but there's a lot of other workers in the workplace in addition to employees. So even if that exemption applies, you still need to be doing these things. And I guess also in this respect, the collection process itself, it has to be fair and it needs to be free of intimidation or deception. Otherwise, your consent that you may get, assuming you require it, may not be valid.
Okay, so once you've stepped through all these hoops and you've recorded the information, there are no problems. Is that right?
Yes, so we kind of have a bit of a parting of ways here. So for employees of these covered organisations, once their information has been collected, it's on their employee record and then an exemption applies. Again, the exemption only extends to the use of that information in a manner related to the employment. So again, you can't go and just splash it around everywhere. You've got to use it in accordance with that. But of course, as I said previously, for your other staff, your volunteers, your job applicants, your contractors, you need to continue complying with the Australian privacy principles, and that basically, as I indicated a little bit before, requires, some compliance practices and procedures. It requires you to have a privacy policy. You need to make sure it's accurate. Is if you've recorded someone as being fully vaccinated, but then they need a booster, there'll be a point when that information needs to be corrected. You need to limit its use. As I said, only disclose it for that purpose that you've collected it for. And generally, and this probably really applies to all the collection, irrespective of exemptions. Like, think about how long you need it for. There may come a time when you no longer need to know whether a lot of employees are actually vaccinated against COVID, and I think we're living for that day, to be honest.
It's interesting. I never realized that people were entitled to keep information to themselves. It seems like everything's collected these days through some algorithm.
It certainly does. I think we would be quite shocked if we really understood the extent of data that is collected, from us in so many different areas. And this is an example of, I guess, what happens quite often in workplace law really is that these other fundamental rights of a person, they do affect the extent to which a business might be able to exercise its prerogatives and tell workers or employees what to do. So yes, the data, I guess, is only going to be more collected and more algorithmed. And this is going to become, an issue in so many different areas, and it's just something that's front of mind here with COVID-19.
So, any top tips, Yoness, both for the business and for the workers?
So for businesses, first does not mean best, but my top tip really, I guess, is if you are going to collect the information, and assuming that people have consented to it and so forth, is really to apply the KISS principle. Just keep it simple, keep as little as you can to satisfy the objective that you're trying to meet. And when you're going about this process, I think it's important to acknowledge and respect the fact that this is quite personal and sensitive information of a person, and it needs to be obviously treated in accordance with the Australian privacy principles, but also just generally in a respectful manner. The second thing I'd say for business is just, I think you need to think about, well, what's the outcome? What happens if someone refuses? Like, do I really want to exit people from the business because they've refused to provide the information? What if they have been vaccinated and they're happy to show you the certificate but not give you the evidence? You've got what you want there in terms of a person being vaccinated. Like, do you actually want to sack that person at that point when they are actually perfectly qualified and maybe, a staff member that you want to keep, putting aside, of course, the issue whether if you go ahead and sack them, then you may very well face some unfair dismissal or other legal claim. So then related to that, and I know this is kind of, less a legal issue, but it's have a think about the workplace culture you're developing. We do try and recognise diversity and differences. People may not be comfortable with this, and I think you've got to operate it on a needs must basis. So big questions here. Not necessarily a straight path to follow, and probably different paths for different organisations, really depending on the nature of the services that they provide. And I guess in terms of staff is, remember, there are privacy rights that are attached to this information. and you are entitled to have it treated in a manner that is required under the law. And really remember that, it is okay to ask questions about that, and you should feel comfortable in doing that. And in a good workplace, ideally, you will have, a matter of fact, consultative and collaborative approach to doing this. And it may be that the provision of information itself almost becomes a non-issue, because only so much is asked of you, and you don't have to provide a copy of your evidence, and maybe there'll be some incentive or additional leave that operates as part of this process. So lots of issues there, and lots of thinking, and I guess another kind of slightly complicated process for organisations to have to go through, but you've got there on mandating or not with vaccination, so this is just part of it.